Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and this week's contract tip has to do with the timing of when a buyer will get their earnest money back when they terminate a contract under due diligence. So I want to caution you, be very careful of your words and how you explain to a buyer that if they terminate under due diligence while within their due diligence time frame, they will get their earnest money back. Now, they will get their earnest money back if they terminate within that unexpired time frame. However, the timing of when they get that back might be at issue. And if you don't explain this to the buyer, they are going to be under the impression that they will get those funds back immediately. Here are a couple of things to consider. Number one, if the buyer remits their earnest money in the form of a personal check, many brokerages have a policy regarding when they will disperse on those funds if it is a personal check. Now, the contract, both GAR and the RE form, do state, as well as license law, that the funds must clear the holder's account before they are required to disperse on those funds. And every brokerage has a policy. For example, Maximum One's policy is 10 banking days. If we receive a check, a personal check, we hold it for 10 banking days before we disperse on those funds. So if a buyer, let's say you have a buyer, you write a contract, you put in 5 days or even 10 days due diligence, and the buyer has remitted the earnest money. So let's say the broker is holding the earnest money, and then the buyer terminates the contract within that due diligence time frame. Let's say they terminated on day 3 after binding agreement date, and they find another house that they want to go write an offer on, and of course that seller will want earnest money as well. Well, the holder, in our case, if we're holding the money, we can't disperse those funds back to the buyer for 10 banking days. So the earnest money is not available to use for that buyer for the second purchase until that time frame has passed. And again, all brokerages have a policy regarding personal checks. So if we're not the ones holding the earnest money, make sure that you check with the holder any policies they have holding personal funds. Better yet, probably best for you as a business practice to deal with earnest money and get it in certified funds so there's no hold on the personal check. Now, the second issue to consider is when a buyer terminates a contract, then there is a form that is sent to the seller, a termination form, and there is a release of the earnest money form. Now, in the GAR contract, both of these issues are handled on one form, and we call it the termination and release agreement. In the RE forms, it is 2 separate forms. One that actually terminates the contract, and there is another form called release of trust funds. Now, it only takes one party to terminate a contract. It's unilateral. Notice of termination is unilateral, so it only requires the buyer's signature. However, it does require both the buyer and the seller's signatures in agreement regarding the release of the trust funds. So even if a buyer terminates a contract within the due diligence time frame, completely allowed for contingency, if you do not get the seller's signature on the release portion of those funds, then the holder, even though the buyer terminated completely within their rights to do so and are entitled to the earnest money back, the holder cannot disperse those funds immediately back to the buyer if the seller doesn't agree and sign the release portion of your termination and releases. Therefore, in the contract, both GAR and the RE forms contract, the holder has to go through the contract, the series of circumstances, and interpret what happened, why it terminated, did the buyer terminate, within an unexpired contingency, and who is entitled to the earnest money back. Then the holder writes that 10-day letter that we talk about, that 10-day letter. They write that 10-day letter. They have to give it out, send the notice to the parties by certified return receipt requested mail, and then you have to wait, the holder has to wait for at least 10 days before dispersing those funds. So the issue again, and then there's issues with objections and so forth and so on. But we're assuming in this case the buyer did terminate within their due diligence period that was afforded in the contract. But in this situation, again, the holder, the buyer, let's say they terminate under due diligence. If you cannot get the seller's signature on the release portion of the TNR, the holder has to go through this process. So let's think about this. And again, let's say you have a buyer waiting to buy put a contract on another house, and that seller is also going to want the earnest money. Well, these funds are tied up. You cannot use these funds until they are available back to the buyer. Timing. So what's the timing on all this? Well, let's say the buyer terminates the contract, and you as the buyer's agent, you send that termination and the release agreement to the listing agent. You don't get their signature back. You don't get their signature back. So that could be 1 to 2 days. You call the listing agent, what's going on? Why won't the seller sign the release agreement? And for whatever reason, the seller is upset, the listing agent can't find the seller, whatever reason. So we're probably already 2 days into this release where the buyer wants to go, the termination, where the buyer wants to go ahead and put an offer in on another property or just wants their money back. So we're 2 days into that. Then you have to notify the holder of the earnest money that the earnest money release is in dispute. So you get that to the holder. The holder then, before the holder is able to get to that might be 1 or 2 days. Then the holder has to go through the contract, find out what happened, why won't the seller sign it, so forth and so on, and write the letter. That might be 1 to 2 days. Then from the date of the notice, then the holder has to get all of the mailing addresses of the parties and send the notice to the parties, and then wait the 10 days before they can disperse. So, and holders don't disperse. Typically, businesses aren't open on the weekend. So if those 10 days go over a weekend, you're looking at the next business day. So, or the next banking day, actually. So a buyer, let's say a buyer terminates under their due diligence period. If the seller doesn't sign the release agreement, we're looking at, from the time the buyer has terminated, a couple days to get in touch with the seller to find out what's going on, a couple days to get it to the holder. The holder might take 1 or 2 days to actually have the time frame to go through the contract, write the letter, so forth and so on. So we're looking at, that's about 4 days or so. And then the notice, the holder isn't dispersing for at least 10 days from the date of the notice. That's another 10 days. So, and then if you have a weekend in there, we're looking at anywhere from immediately, best case scenario, 10 days to 14, 15, 16 days or so. That's a long time for a buyer to potentially wait for their earnest money when they did terminate under due diligence. When you explain to them, oh, no problem, you terminate under due diligence and you'll get your earnest money back. Well, yes, they will get their earnest money back, but the timing of that, they're thinking they're going to get it back immediately, and we just went through the calculations. It could be anywhere from 10 to potentially 17 days. So just a couple of things to think about when you are speaking with your buyers and dealing with earnest money, getting them their earnest money back when they terminate under the due diligence period. Thank you so much for watching. Again, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.